Hi Frank, hi Liz. Really good to see you. Hope you're
Yeah,
having a grand wee time approaching summer between torrential rain and beautiful sunshine. It was really good that last time we chatted, Liz and Frank, about some of those kind of questions that people kind of come up with, and indeed I do too. And another one that has kind of crossed certainly my mind and other people I've spoken to is a confusion about those terms that are used to describe personal data, particularly given that current data protection legislation have got different terminology. Can we maybe have a wee chat around maybe a little bit to help people understand those terms that are used to describe it?
yeah. I think the one that comes up most often for me is the use of the term sensitive personal data, which doesn't really exist, as you were saying, Heather. The
Yeah.
legislation is different now, so that's the terminology of the old Data Protection Act 1998. There's no mention of sensitive data in UK GDPR. It's special category data now. Um, But I suppose, that does give us a wee bit of flexibility, doesn't it? In that
Mm.
there are other sensitivities beyond those listed in Article 9 of GDPR.
And I think also maybe what I think in particular because sensitive, I think people thought about sensitive data, and obviously under the old legislation it was included in there, but people also think about their security classifications and maybe think about commercial sensitive and personal sensitive, and that's what also confuses them. So if I maybe kind of focus around about what it is now in terms of personal data. And there's, I guess, that the two areas we've got the special categories of personal data, and then we also have criminal convictions, which includes personal data, but would not be categorized as sensitive data.
I I think the one one of the areas this comes up most often is personal financial data, which of course is not at all, it's not special category data. And I
Yeah,
sometimes joke you can tell the GDPR was not drafted by British people because we
indeed.
tend to be a lot more twitchy about financial matters than other cultures. But that's an area where most of us would consider that to have a degree of sensitivity, even
Sure.
though that's not how GDPR treats it.
Yeah.
And I think there's scope. I mean, I personally prefer what we have now because special categories that basically, as Frank said, I think there are other data fields because we all know that data protection is totally context driven, and actually what
Yeah,
is sensitive to one person and high risk is not necessarily sensitive or as sensitive to the next person. And we see cases all the time, things like home addresses. Some people home addresses is much more sensitive if they're vulnerable in some way,
Sure.
than other people who would, who have their home address permanently in the public domain for one reason or another.
Yeah.
And so I think it's actually it's quite useful that phrase is no longer used by the legislation, because you've got other things as well that quite often cause confusion. And the one for me is around equalities legislation, because
Mm.
of course people often talk about equalities monitoring covering special categories of personal data, which of course it does, but not all of the protected characteristics are special categories of personal data,
Sure.
because age and gender of course are not in there. So I think it just gives a little bit more scope and a little bit more ability to apply the legislation in the context of your organisation to use that term sensitive, where you're actually referring to risk-based processing.
Yeah, and I
yeah,
think that I think the key message also is get across when it comes to the sensitive data categorization, it's absolutely got to be based on the situation, and that's what makes a difference. Because as you said, somebody's home address might not be of any relevance and not at all sensitive at all or risk based, but for somebody else who does not want to be sharing that information
yeah,
because great harm could come to them, then suddenly it's way more risk laden.
yeah. And certainly, sometimes I find the definition of special categories data in Article 9 a little bit of a blunt instrument. Because if you think, for instance, of health data, that's all special category. That all requires an Article 9 lawful basis as well as an Article 6 lawful basis, and protection of the access. But clearly there's a great deal more sensitivity and risk around something like sexual health data
Sure.
than there is around some of these dental records. So yeah, I think being able to apply that risk-based, a little bit of nuance there in terms of recognising that, yeah, there's sensitivities outside of the special categories, but there's also different levels of sensitivity even within special category data.
No, absolutely. And again, I think we always have to look at the context and individual circumstances, big style.
Yeah, the one other place that I think it is helpful is where you have sole traders. So it kind of leads on from Frank's point, really. But because we talk about commercially sensitive, particularly those that are in the public sector and that work with FOI, when we talk about what is personal data, and of course for sole traders, that is going to include their business data, which other companies would also find sensitive. So again, it just allows us to talk about data types in a different way. So while we obviously need to acknowledge that business data is also personal data, we can still use the term sensitive to refer to a much broader range. But it does come back to the fact, if we are putting it under data protection law, we need to be completely clear that the data we're talking about is personal data.
Sure. It's about that explicit element, which is what we now get more with the current legislation than we maybe had before. I guess the particular area sometimes that, and it certainly has confused me and others that I've spoken with, is that you would think that information relating to an individual's criminal convictions and offences ought to be special categories of personal data, but actually it doesn't come under the special category, but it's still counted as personal data.
And that's another change from the old legislation, because the old sensitive personal data category in the Data Protection Act 1998 did include criminal convictions data, but it's deliberately left out of Article 9 in GDPR. And that's not because there's no sensitivity there. It's to give all the countries of the European Union a bit of flexibility to legislate for how you can authorise the use of data about criminal convictions and allegations of criminal activity. I think that this maybe the quickest shorthand is to point out to people that essentially the Data Protection Act 2018 does that in Schedule 1, where it creates lawful basis for the processing of criminal convictions data, which very similar to the lawful basis in Article 9 for special category data. So it's a little bit of a crude oversimplification, but essentially one of the things that Schedule 1 of the Data Protection Act 2018 does is to allow us to treat criminal convictions data alongside other types of special category data. And of course, we always have to have a very particular legally authorised purpose for using that sort of data.
Absolutely. No, I think that definitely helps to clarify it, and hopefully all of you watching our little conversation feel the same way, but feel free to send in your comments and thoughts and other questions. Thanks very much, guys. That was excellent.